Well, dang, that was fast. Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only, and just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so besides the fact that 1122 King is now gone, what was the last thing that we talked about in the Idaho case? Yeah, the defense wanting to challenge the fact that Bryan Kohberger's motions to dismiss were both denied, basically wanting the entire thing done all over again. I believe the way that the little video clips that we went over trying to understand what that whole interlocutory, that word, what that meant was that they basically wanted an instant replay of everything that just happened because they disagree with the decision, and the decision for both parts of the motion to dismiss were denied. Well, they've already set a court date, and it's going to be in just a few weeks. Order setting hearings on defendant's motion to reconsider or for permission to appeal, and on the state's motion for scheduling order. Based on the state's motion for scheduling order filed December 21st of 23 and defendant's sealed motion to reconsider orders denying motions to dismiss indictment, and in the alternative for permission to appeal from interlocutory orders and a stay of proceedings filed on December 21st of 23, the court orders the following. A hearing on defendant's motion to reconsider orders denying motions to dismiss indictment, and in the alternative for permission to appeal from interlocutory orders and a stay of proceedings will be heard on January 26th, 2024, beginning at 11 a.m. Pacific Time. The court will hear argument pertaining to the sealed order denying motion to dismiss indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. This hearing will be sealed and closed to the public to protect the privacy of the grand jurors and the grand jury's procedures. That's the exact same way that things were handled with that portion the first time. At 1 p.m. Pacific Time, the court will hear argument pertaining to the order denying motion to dismiss indictment for inaccurate instructions to grand jury. This hearing will be open to the public. The public and the media may attend in person or can watch the live stream feed of the proceedings found. And I know that some people were having issues with this link already. I'm noticing a couple of comments in my community post about it. Now, all you really have to do is type in like Judge John Judge or whatever in the Google search bar, and his channel will pop up because that's actually what it is. But I actually subscribed to this channel a couple of months ago, I think. It was whenever they announced they were going to actually start doing this, whenever Judge John Judge said that he was going to take control of the whole camera situation. I don't think it was a few months ago. Maybe it was. I'll have to just go back. There's been so much information on this case, and it doesn't feel like it's even been an entire year. But then whenever you kind of like sit back and you think about everything that we've gone over, all the different topics, all the different things that have come up, all the different motions, it's been a lot. Anyway, that will be in the description box if you guys need that link to go and subscribe to that channel. Again, it is like labeled as Judge John Judge's channel, but it is where all of these court hearings for this case are going to be streamed that are deemed public. A scheduling conference will begin following the conclusion of arguments on defendant's motion. The scheduling conference will be open to the public and live streamed on the court's YouTube channel at the link above. And see, that is the scheduling conference that the state requested, I don't know, like a week or so ago, whenever we found out that they were requesting for the trial to actually begin the summer of 2024, so just this next summer. And that was one of the things that the Goncalves family mentioned in their family statement about 1122 King being demolished. And the next video that I actually post later on tonight is going to be about the Goncalves family statement on the Facebook page. Yeah, that one's going to come out here in a few hours. But I wanted to get this document out there to you guys because it does seem like maybe they're taking a little bit of what the families maybe want into consideration, or they're just kicking things into gear because they know that they just have to. I mean, all of this was just requested. Like all of a sudden it seems this is kind of normal for this case, right? I feel like this is how it always is. Like now that I'm stopping and thinking, it's like there's a null, and then there's like bam, bam, bam. And then there's null, and then there's like bam, 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 bam. You know what I mean? And we've had a lot of things happening all of a sudden over the past, I don't know, couple of weeks in this case. And now we have a new court date coming up because we're going to be going through this entire motion to dismiss thing all over again. But this is the question that I have for this portion of what we're seeing. We basically knew whenever the motion to dismiss hearing was over last time that failed. We basically knew that already. Judge made it very clear that he wasn't impressed by the argument, right? Like in the public one. But then we had the paperwork actually come out for it. And then all this other stuff started filing. And really, that paperwork getting dropped about the denial being like official on paper for the motions to dismiss is kind of what kicked all of the rest of this off. Like we knew that they were going to be getting rid of King Road on the 28th, but then like we kind of just watched them go in and out the house and do this and do that, and there wasn't anything to really go over or any new information. And then the decision was dropped, and then all this stuff started happening. So my question, I guess, is it going to be the same thing here, where by the end of the session on the live stream, we kind of know if Judge is going to change his mind or not? And something else that I was curious about is if this is going to be like the exact same information being presented, or if there was something that the defense sort of held back for just in case purposes. Like maybe they thought what they had was good enough to maybe get them what they wanted, but just in case they kept like something real good. Are we going to hear something else? Or is there going to be something new presented in the private session that happens in the morning? Or are they just going to be representing all of the exact same stuff all over again, expecting a different result this time? And I know this is going to be a little bit off topic, but it reminds me of the way that my job kind of works. So if a claim goes in and an insurance company says, okay, we have the claim and these charges are covered for the patient, but we need medical records first before we can make a final decision. So we send the medical records, they review the medical records, and then say that they deny the claim. They deny making any payment on their patient's claim. Well, they always say that we have appeal rights, right? They call it that in the medical field too. You have appeal rights, or you can file for a reconsideration, something like that. I always find those so unnecessary. And I'm like, well, what are you really expecting me to do here? Because I can only send you the exact same medical records for this appeal or for this reconsideration that I've already presented whenever you asked for the medical records to begin with. So it's kind of like a process that you have to go through, because you can't just be like, oh, well, they denied it because they didn't find it medically necessary, so just bill the patient and move on. No, we have to, there's like steps that has to be taken. Laws like basically tell you when it comes to this kind of thing that you just can't take it and run with it. You have to prove it, because it could come back to bite you in the butt later. So if this happens, you have to appeal it. You have to work it. And because we've already sent in the same medical records that we're going to have to send in, because appeals and reconsiderations, that's the whole point. You send in your supporting documentation, which is the same thing here when it comes to evidence that supports the guilty or the innocent situation here. But if they've already done this whole motion to dismiss thing, and they have already presented what they believe is their supporting documentation for why they believe that these things should be dismissed, if they just present the exact same thing, what's the point? It's just like how I feel about those kinds of things. Like, I know I have to do it. I know I have to, but I know it's pointless because they've already seen my evidence. They've already seen my supporting documentation, and it didn't work. It didn't work in our favor. It still got denied. So that's what I'm curious about. Is there something that maybe they held back that they think is going to change something this time? Or is this them really just trying to do everything that they know that they have to prove that they fought the right kind of fight that they're supposed to fight, like all of the processes, so that Bryan can't say that he had ineffective counsel? I don't know. At this point, it just feels like so much wasted tax dollars. Just get to the trial already. Let's just get this freaking over with. This is stupid. But yeah, that's the latest information, and that is the newest court date as of now. That's it. If you guys like this video and the way that I present this information, please do not forget to leave a like on the way out and subscribe to the channel if you are not subscribed already. See y'all.